Hello, everyone. Thank you for joining us in our complimentary webinar series for the U.S. federal government contractors. We are coming to you live today from Washington, D.C. You probably found out about today's webinar through our newsletter, which reaches over 23,000 federal government contractors and service providers. Today's session is complimentary and also recorded. You can find the recording on our website and YouTube channel about 24 hours after the webinar. We have over 525 complimentary webinars on our YouTube channel. This includes all 52 parts of the FAR and all 52 parts of the DFAR and hundreds of webinars on strategic and tactical topics. If you would like to advertise in our newsletter or in any of our upcoming webinars, please email us at hello@jennifershaws.com. All right, so a little bit about us. We are a specialized consulting firm focused on working with established federal contractors. We work with product, service, and software firms across the globe. For more information about our services, please visit our website and select About Us. As mentioned, today's webinar is covering the FAR supplement. It is complimentary and recorded. We began the series in January 2022, and you can find these past recordings on our website as well as future schedule and registration links. As you can see here, we have covered several of the FAR supplements already, and we'll begin winding down the series August 24th with the Veterans Administration. Then on Fridays, we cover the same agency or department in a Playbook series. The Friday webinars discuss upcoming bidding opportunities, contracting trends, small business resources, and sometimes feature a government speaker. The full schedule and past recordings are on our website under the Playbook tab. And now we'd like to thank our sponsors who help make the webinar series possible. We would like to thank the Virginia PTAC. The Virginia PTAC is based out of GMU in Fairfax and offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group training are free with no restriction on business location. If you are interested in learning more, please use the links provided to explore what PTACs can offer. And a special thanks to the Federal Business Council. The FBC creates and manages virtual and in-person meetings and events to connect appropriate industry and government thought leaders, product providers, and solutions with government programs that use them. The FBC works within mission-specific programs for a variety of agencies to connect government and industry in the form of in-person and virtual conferences, training events, policy dialogue, and outreach. Over the last 40+ years, FBC has become a comprehensive resource for connecting industry and government and the federal government. Daston is an IT and cloud solution provider working with corporations, the military, and government agencies to lower their costs, increase scalability, improve operational efficiency, and meet compliance regulations using targeted cloud-based solutions. Daston is a certified partner of Oracle NetSuite, a premier tier Google Cloud partner, and a certified partner of Cisco, Virtue, AODocs, and Authenticate. For more information about Daston services or to schedule a complimentary consultation, please email Joe Alston. His contact information is in the lower left corner of your slide. You can also visit the Daston website. Please join us at the Kennedy Center for a night of networking with over 200 federal contractors. Our quarterly event will take place on Monday, June 20th. Sponsorship opportunities are available. Federal agencies will be present and will be listed as they confirm. Please note that ticket prices increase on June 13th. We hope to see you there. Thank you again to the attendees and our speaker for joining us today in our FAR supplement series. We are here today to dig into the FAR supplement on the Department of Commerce. Our speaker today is Joshua Duvall, and he represents the firm Maynard. As a reminder, we do not take questions, so if you have questions for Josh, his contact information will be displayed at the end of the presentation, and you can contact him directly. Thank you, Josh, for joining us today. I'll put myself on mute and wait for your cue for the next slide. The floor is yours.
Thank you so much, and thank you everyone for joining us today to discuss the Commerce Acquisition Regulations. My name is Joshua Duvall. partner in the Washington, D.C. office of Maynard Cooper and Gale. It's an honor to be here and appreciate the invitation to discuss the regulations. One of the things that I'd like to talk about up top is that the Department of Commerce regulations are quite dense. And so today we're really just going to provide sort of a scenic tour through the Federal Acquisition Regulation and the Commerce Acquisition Regulations, hitting on a couple key topics. As always, if you have any questions, feel free to contact me at my emails on the screen, as well as my phone number. And for those of you who know me, I do regularly blog, and so please feel free to follow that on LinkedIn. You can go to the next slide. And so we're here today again to talk about the Commerce Acquisition Regulations. Notably, as I was thinking about this, I don't know why the regulations here is plural. That's how they've called it, which is slightly different than the Federal Acquisition Regulation, which is in the singular form. But if we can go to the next slide. A couple things to think about at the top. This slide might be a little bit difficult to see, but I pulled it off of the Department of Commerce's acquisition policy website. So what we have are sort of an amalgam of things to think about, not just with the Commerce Acquisition Regulation, but also how the Department of Commerce conducts its acquisitions. Here we have their acquisition directives, the Commerce Acquisition Manual, which on their website is sort of segmented by part, various handbooks, and again here in the middle we have the Federal Acquisition Regulation, and below it the Commerce Acquisition Regulations. So if we can go to the next slide. The scope of the part really addresses the Department of Commerce acquisitions. Many of you might be familiar with various agencies and bureaus within the Department of Commerce, like Census, which recently did its census report, or it's in the middle of that. NOAA, the National Oceanic and Atmospheric Administration, which anecdotally has one of my favorite websites in government, and United States Patent and Trademark Office. And so if we can go to the next slide, at the top we see the CAR establishes these uniform procedures to implement and supplement the FAR. And notably, if there's a discrepancy between the FAR and the Commerce Acquisition Regulations, the FAR will take precedence. And so, as I mentioned, the applicability goes to Department of Commerce acquisitions. And so, as I mentioned, we have NOAA, Census, PTO, and the like. If we can go to the next slide. All right, so now with sort of the beginning framework sort of outlaid, one of the things I wanted to talk about was contracting officers' authority. As we can see here, and as not a typo, we have the CAM, that is the Commerce Acquisition Manual, which is what I referenced earlier. And one of the reasons I wanted to talk about contracting officer authority is, as contractors are doing business with the federal government, we have sort of two shops, for lack of a better way of explaining it. We have the contracting shop, and then we have the program shop. And up until the point of award, contracting officers are dealing with the folks that have been bidding on these procurements, and then you get into the swing of the procurement. And most often you're dealing with coders, contracting officers, technical representatives, contracting officers, representatives, program folks. Those are the folks who are sort of, providing guidance and direction and things. And the contracting officers may not be involved in the day-to-day minutia of the procurement. But what often happens is a contractor will get some sort of direction or request from somebody that's on the program side that will either increase the amount of the work or the scope of the work. And it's important to remember that only contracting officers have authority to bind the government. And that can end up contractor in a pinch where the government says, well, you did something that was outside of the scope of your contract and there was no modification. If we turn to the Commerce Acquisition Manual, they provide, now the FAR has a definition of contracting officer, but I'm pointing specifically to the CAM, which is 1381.70. It says contracting officer means the an individual with the authority designated by the senior bureau procurement official to enter into, administer, and or terminate contracts and make related determinations and findings. And so just as a word of caution, if you're doing business with the government, and you're getting directions that will increase your costs or the scope, to loop in the contracting officer and to get those new instructions put down in writing in a contract modification. One thing to think about, when folks are submitting claims to the government under the Contract Disputes Act, you're requesting a contracting officer's final decision, not a contracting officer's technical representative final decision, not a core final decision. It's the contracting officer that is providing that determination, which then would enable the contractor to go to a board or the Court of Federal Claims on appeal if the claim was denied. So that's something to be aware of. The government, in some instances, the contracting officer specifically can ratify the conduct of an unauthorized type of commitment, but we want to avoid that at all costs. So, if you're receiving that information from the program folks, be mindful to loop in the contracting shop and specifically the contracting officer. So we can go to the next slide. Deviations, I think the Commerce Acquisition Manual points to the procurement executive that has the authority to do this. I think most of us have heard of the class deviations that were going around for the COVID-19 pandemic. We had the FAR Council introduce the FAR clause, and then subsequent agencies were issuing their class deviations in accordance with that. So anytime there's going to be a deviation from the FAR, that is the process that is set forth in the Commerce Acquisition Regulations under this provision. And so, as they do come up, that is the process that the government will follow. If we can go to the next slide. Now, sort of pivoting a little bit, now we're into part 1303, which is improper business practices and personal conflicts of interest. We've seen a lot of, or at least I have, over the years, of agency officials being caught in an unfortunate predicament where they're taking bribes or accepting gratuities. The Department of Justice is out there doing their work to ensure that the procurement system is not filled with fraud, waste, and abuse. And so here we have the standards of conduct and the entity to whom these violations should be reported, which is the Office of Inspector General. And the other item that I wanted to bring up here is procurement integrity, which is under 1303.104. Procurement integrity is a big issue in federal procurement, not just because of the most obvious reason is procurement integrity in the name of the Procurement Integrity Act, but also because of the consequences of a violation. And when we're talking about procurement integrity under the FAR, we've got language under FAR 3.104 that says that you're not supposed to, a person shall not knowingly disclose contractor, bid, or proposal information or source selection information prior to award. It also says that a person shall not obtain that information. Now, the Procurement Integrity Act violations, as I mentioned, can have stiff consequences. One consequence is disqualification, and that happened in a protest not too long ago that was before the Court of Federal Claims, where this information was shared to a party, and the alleged violation was reported, as is required under 41 U.S. Code 2106. So that's the 14-day requirement, which is strict, and you'll have a denial if you don't follow that procedure. But there, the court found that the way to level the playing field instead of canceling the solicitation would be to disqualify the beneficiary of that bid and proposal information. Notably there, at least based on the way the opinion was written, it didn't really seem like the disqualified bidder really was at fault. They were just given the information, and it was for a security contract overseas. So that's something to be mindful of. Obviously, folks have proprietary information that they want to keep protected. And so if you have a suspicion that there has been a violation of the Procurement Integrity Act, consult with your inside or outside counsel, check the regulation, be mindful of the 14-day requirement. GAO protest decisions and Court of Federal Claims decisions also have some useful guidance on that, but this is a big deal, and as I mentioned, it can result in disqualification. So that's something that folks need to be aware of. Otherwise, they lose that opportunity if, for example, you miss the 14-day deadline there. If we can go to the next slide, one of the other items here, skipping ahead now again to Part 1306, competition requirements, is this notion that we have full and open competition. But with that being said, the Department of Commerce follows the FAR and under 63032 to provide a justification in the instance that full and open competition is not met. When we think about competition, we think about having as many offers as possible to be able to compete. When we look at these items of limited or single source or sole source competition, the FAR identifies 7 items, right? So we have only one responsible source, which sometimes comes up, an unusual or compelling urgency. We see that somewhat regularly when the government is trying to provide a justification for sole sourcing a requirement. Industrial mobilization, engineering, developmental, or research capability or expert services is another reason. International agreement is the 4th. If it's authorized by statute, that's a justification for other than full and open competition. National security is the 6th reason, and finally public interest. And so for those of you who have not received a sole source or have been tracking a procurement that was involved with a sole source, or if you've been involved in a protest, sometimes the agency will be coming up to a lapse in services and they'll issue a sole source to continue on. The agency's got to provide their justification, and typically it explains the nature of the services, the amount of the sole source, what reason, which of the 7 things that I just mentioned the agency is relying upon to make its justification. And again, when we're thinking about federal procurement, we're thinking about this competitive environment, but there are ways for agencies to get out of that, and the justification process is the path that they follow. If we can go to the next slide. Now, again, we're jumping ahead to Part 1315 here, contracting by negotiation. And a lot of folks are probably familiar with FAR Part 15. This is the supplement to FAR Part 15. And what we have here are a couple items that I wanted to highlight. 2 here says the contracting officer shall insert the provisions similar to 1352.215-74. I'm going to pull that up here because I wanted to talk about that, as well as paragraph 3, 1352.215-75 evaluation criteria. So we'll see these, and again, as I mentioned, commerce, census procurements, we'll see them in NOAA RFPs. We'll have these clauses that are in there. And so what 74 basically says is a couple things. One, the award will be made, as many of you are aware, to the offeror who's conforms to the solicitation requirements. And it also goes on to say that all offers received will be evaluated in accordance with the stated evaluation factors and criteria. And so what do we have here? Going to the next slide. What are those evaluation criteria? And so this is what we'll see in Department of Commerce solicitations. We have these evaluation criteria as provided under 1352.215-75. And we can see that .52 are the contract clauses. So 1352 is the supplement to those contract clauses, contract provisions. So here we have what Department of Commerce is going to be doing. They're going to be looking at your technical approach, your experience, your key personnel, which again, I think is a big thing in federal procurement. We have a bit of a rift between GAO cases and Court of Federal Claims with respect to key personnel and what happens in the event that you become aware that a key person is no longer available. On the one hand, GAO says if you have the knowledge of that unavailability, you have to update the agency and let them know, and they can either open up discussions or they can call your proposal technically unacceptable. And on the other hand, at the Court of Federal Claims, where they found that there is no such requirement. And so, as you're dealing with key personnel requirements, you see them in your RFPs and solicitations that are coming out. These are things to think about in how it can potentially upend an award. Past performance is the fourth factor here. The offers past performance on related contracts and subcontracts. Is that on this page? Yes, it is. As appropriate. Now, notably below that, which I did not put, the next sentence is the government reserves the right to assess the past performance of proposed subcontractors. Is that on the next page? Yes, can we go to the next slide, please? So one of the things to think about here for those of you that are small businesses, we have typically agencies will evaluate subcontractor, particularly if they're a major subcontractor. The FAR uses the word should, which is a permissive term. It's not a mandatory term like must. But for small business, there was a new regulation. When I say new regulation, I truly mean new regulation. It didn't exist until November of 2020. And that regulation said that for small businesses that propose a team of small business subcontractors, the agency's got to look to that past performance capabilities and experience of those first tier subcontractors where the prime contractor doesn't have it. And that's under 13 CFR 125.2G. And that's an entirely new regulation. So we have here, the sentence that says that, what the agency reserves the right to do. Title 13 in the Code of Federal Regulations says with respect to small business, this is what they must do. And so they must consider those. And so again, not to sort of dive too deep into the weeds here, we have FAR Part 15 and its processes and procedures that outline what's going on here. We have in the Commerce Acquisition Regulation, the evaluation criteria that they're going to follow. As I mentioned on the previous slide, they've got technical approach, experience, key personnel, and past performance. And then here we have how they're going to continue on with their evaluation. Interestingly, cost price is not evaluated, is evaluated but not scored. That's, I think, a little bit interesting. They will reserve the right to adjust for a most probable cost. Now, one of the things to think about at the very bottom here, we have the word cost/price realism. I think folks need to think about this as they're heading into procurements that are fixed price, and that is when the government purchases on a cost basis, they are obligated to compensate for actual and allowable costs. And so you've got price realism where cost realism where the agency is going to determine whether or not, what the true cost is that they're actually going to pay. When you have a fixed price contract, as many of you are aware, the risk is on the contractor. It's no longer on the government. The contractor is bearing the risk of its pricing methodology. So ordinarily, a price realism analysis in a fixed price context is not required. Now, you may see language in the solicitation that puts offers on notice that one will be conducted. It's something to think about, especially for folks that are worried about a competitive market with low bidding and how that favorable price might potentially sway an award. So that's something to think about as we're going through. If we can go to the next slide, please. I mentioned small business earlier with respect to past performance. Part 19 is small business under the FAR. So we have, again, 13.19. Interestingly, I put this up because I think there's a little bit of a statutory hiccup here with how things have been codified and fixed and through various rules. 13.19.505 is rejecting small business administration recommendations. That actually coincides with FAR 19.502-8. Many of you are aware that 19.505 is the limitation on subcontracting provisions, which for small businesses means that you cannot subcontract in a services contract more than 50% of the work to entities that are not similarly situated. And so without really going too deep into that, what that means is if it's an 8A contract, you can subcontract to an 8A above that threshold. But if your subcontractor is a service disabled veteran-owned small business or a large entity, you're limited to the 50% rule. Here again, we're pointing again to the Commerce Acquisition Manual for the designee. And again, this is set up to ensure that there's a proper procedure in place for rejecting any of these recommendations. And so, for folks that are encountering situations where the agency is doing something that you think is contrary to what Part 19 or Part 13.19, you can see where the line of higher ups are going to go for each particular matter. And here it says the designee is going to be under 13.1-70, and I believe again that's the procurement executive. I can double check, but that's in CAM 13.1.70. So if we can go to the next slide here, again, I just wanted to call attention to patents, data, and copyrights. These are, again, important provisions. And what we see is under the FAR that the scope of Part 27 prescribes the policies and procedures with respect to patent and copyright infringement, liability, royalties, security requirements for patent applications and containing classified subject matter and patented technology and trade agreements. So there's a lot of contract clauses under the FAR. We have some additional items here in the Commerce Acquisition Regulations. Again, we're pointing back to the Commerce Acquisition Manual for designees. Something to be mindful of, we have a robust system that's sort of woven together. As I mentioned on one of the earlier slides, we have the FAR, we have the CAR, we have agency deviations, and we have the Commerce Acquisition Manual. So all of these things are part and parcel of the acquisition policy and system of the Department of Commerce. So if we can go to the next slide. Again, we're talking about service contracting. Here, a couple things to think about. Right off the top, 1337, 11070 are the personal security requirements for contractors that are doing business or performing services for the Department of Commerce. So if we scroll down and you can see insert clause on paragraph B, the security requirements for moderate to high risk. This basically tells contractors that for IT services contract, whether it's a high risk IT services contract or a moderate risk IT services contract, a background investigation is required. If it's for non-IT services, for high risk, it would be a background investigation and then an MBI, which is a moderate. So there's a lower threshold there. It also describes the fact that the contractor's got to submit SF 85P, fingerprint chart, credit release. Back prior to my time practicing law, I worked for government contractors in and around the DC Beltway. And one of my clients was a civilian agency, and I had to undergo, the SF-85P to get a public trust clearance to do the work. And so it's something to be mindful of. Again, in this competitive world, folks are trying to hire and be timely and be competitive. And so here we have the requirements that are going to be in play for those moderate risk contracts. And again, there's a sort of bifurcates between IT services as well as non-IT services contracts. So that's really what I wanted to talk about under services contracting. If we can go to the next slide, we have 1339, which is the acquisition of information technology. One of the things that the FAR talks about, and that's I think important, is that information technology is not stagnant. It's always changing. It's a fluid thing. And one of the things that agencies are required to do under the FAR is to think about the risk ahead of time, right? And that might be schedule risk of the project, technological obsolescence. So when we talk about the speed of procurement, is what we want going to be obsolete in 5 years? How are we going to think about that risk? The cost risk of the procurement, the risk in a particular contract type. So, whether it's a cost plus incentive type of arrangement or a firm fixed price, how are those risks allocated? And so we've got a lot of important things that the agency is going to adhere to at the front end. I just wanted to call folks' attention to that. When we think about NOAA, for example, they have a significant, as I guess every federal agency, but they've got a lot of IT with their research and with satellites and looking at hurricanes and weather and the atmosphere and the oceans. And so there are certain things that they're going to be thinking about as they do their business. And I think that's basically what I wanted to talk about with that. And finally, we're coming up to the bottom of the hour here. And our last slide of the day before I do a recap is termination. So if we can skip ahead one slide. This was, sorry again, that was, the previous slide was just describing what I just talked about. Termination of contracts. One of the things that I think is worth noting for folks that are doing business with the federal government is contract terminations. The FAR provides termination for convenience and termination for default in whole or in part, and we have procedures in place at the Department of Commerce for that. And the reason I bring this up is, at the end of the day, folks, a lot of the times are worried about getting into the procurement, winning a bid, putting together a proposal, putting together the team, worrying about, as I mentioned earlier, how past performance is going to be evaluated. If it's a small business procurement, it must, in certain circumstances, be evaluated. How your key personnel are going to play into the mix. But then when the award happens, and you're into the swing of the things with the actual work to be performed, you have the issue I mentioned earlier with respect to modifications. Maybe you're getting instructions from the program side or the contracting officer's technical representative to do something that's going to increase your cost or increase the scope of your work, and you want to be mindful to bring those issues back to the contracting officer. And here this goes to the notion of fulfilling the obligation, right? And so the government as the sovereign has the right to terminate for convenience, which is something you don't ordinarily see in the commercial context. And again, we have the more, I guess, scary termination, which is for default, right? And so, contractors want to be mindful of that. We have a little bit of background here, but suffice to say, it's something to think about as we bookend the conversation today here. Again, sort of in summary, we have the Department of Commerce acquisition regulations. We have the Commerce Acquisition Manual. We have this scheme in place that serves to supplement the FAR, and as I mentioned earlier on, to the extent that there is a discrepancy between the FAR and the Commerce Acquisition Regulations, the FAR would govern. And so anytime that you're getting ready to do business with the Department of Commerce, whether it's a procurement through NOAA or the Census Bureau or any other covered entities, that these are in addition to any FAR provisions and clauses that you'll see in a solicitation, you'll most certainly see some of these, as I mentioned, under the evaluation criteria. You'll see how the Department of Commerce includes technical approach, experience, key personnel, and past performance, and that they will evaluate your price, but it may not be scored. Now, of course, there may be solicitations that have slightly different language in there, and that's something to be mindful of as you're going on doing business with the Department of Commerce. I think if we go to the next slide, that concludes today's webinar. I appreciate everyone for attending. Again, the Commerce Regulation is about 100+ pages in double column format, and so we tried to cover some of the highlights today and to give you a little bit of an overview of federal procurement as we're weaving through the scenic tour of the Commerce Acquisition Regulations. I appreciate your attention. My contact information here is on the screen if you have any questions. I very much appreciate Jennifer Shasa and Associates for the opportunity to present to you today. And with that, I'll turn the reins back over and mute.
Great. Thank you so much, Josh, for a great presentation. Thank you to all who participated. The recording and slides will be available within 24 hours or less. Once again, please join us at the Kennedy Center for a night of networking with over 200 federal contractors. Our quarterly event will take place on Monday, June 20th. Sponsorship opportunities are available. Federal agencies will be present and will be listed as they confirm. Please note that ticket prices increase on June 13th. We hope to see you there. This concludes the webinar. Thank you so much, everyone.